We have somebody here that wants to do a land patent, and they're getting information from attorneys and from their searches on the internet that they're invalid or no longer used.
Okay.
Shocker. And so he sent me a petition to the Supreme Court for an appeal to try and settle it. So I'd like to just go through a few of these questions and see what you have to say. Sound good?
Okay, I don't see your document, but...
Can you see it now?
There I can, yes.
All right, so United States Appeals Court, Third Circuit, they're the ones that last ruled on the merits of the case. And so this is a petition for the Supreme Court of the United States. Here's the questions. 1, if one is entitled to update a land patent, is there a time of day, time of year, season, weather event, or anything that would bar the update?
No.
Okay.
That's open 24 hours a day, 365 days a year, forever.
Right. So you can bring your link and connect it to the chain of title.
That is correct.
And so it doesn't matter what day or time or any of that.
That is correct.
Did the land patent lose its legal authority?
The land patent never had legal authority. It only has lawful authority.
Yep.
Legal is administrative. The patent is not within the jurisdiction of the legal administrative framework. It has no jurisdiction there. The reason that the lower courts rule against it is because they're in an administrative capacity, and they don't want us to have land and rights. With the land patent, you have land and title to that land, true title and only title, and you have a bundle of rights called vested rights. Can never be taken away.
Okay, so the next question is, if a land patent does lose its legal authority, is it non-pro-tunc from the beginning?
Well, it's valid from the beginning. It's the creation of a forever document.
Right. And so it didn't lose its legal authority, but people accept an alternate which has legal authority.
Well, it depends upon the definition that they're using with legal. We use legal in many instances where it should be doing lawful. The word legal technically is within administrative jurisdiction only.
Yes.
You understand what I'm saying here?
I do. I do. But it can even get more technical than that when you talk about unincorporated trusts, because there's
and that's the thing.
Yeah.
But people are not used to what the language that you and I and the understanding about what we're even talking about. But it does not, if you want to use the legal in conjunction with lawful, it does not ever lose its lawful or legal standing.
Yes. So just to be clear, this is about lower courts ruling against the land patent. So in context to this document, legal is referring to these commercial or administrative courts. So we're talking about attorneys and legal dictionaries and that whole realm.
That is correct. That's correct.
Okay, here's the next one. Does treaty law and constitutionally secured rights fall under federal jurisdiction?
Well, here again we get into this issue of what is federal. Federal is corporate. So, boy, I don't know how to answer that without confusing the hell out of it.
Well, maybe I could give it a try and you could give me feedback.
All right.
So the federal government has a fiduciary duty to honor, but they confuse what side of the line people are on with legal persons and all of that sort of stuff. So today, it's almost entirely legal, and they don't recognize lawful people very easily anymore.
Well, yeah, but by doing that, it's unlawful to do that because we're flesh and blood, and the patent is forever.
Right. So if I read the question again, does treaty law and constitutionally secured rights fall under federal jurisdiction? If you look at things like 18 U.S.C. 2071 for concealing the public record or destruction or alteration of public records, or if you look at 18 U.S.C. 241 and 242, which is deprivation of rights under color of law, if you look under 18 U.S.C. 245, which is federally protected activities, you'll see that treaty law and constitutionality is under federal jurisdiction. There is some honor in the United States Code.
Yes.
But there is confusion about who gets the relief or the protection from it.
Well, let me give you another one that you might want to put in your response there to these people. If you go to Title 43, Section 57 and 83, it states that any certified copy of a land patent can be brought to any court in all courts in the United States. Now, here's where these lower court rulings have got a real problem, because they're bound by the Constitution to protect that land patent. And that's what the Title 43, Sections 57 and 83 identify. And it says the courts must, you have to look at the language, must means mandatory, take judicial notice of its evidentiary effect. Now, boy, that's powerful as hell, simply because they cannot denounce, they cannot reduce, they cannot alter that patent.
Comes from a higher jurisdiction in a forever contract.
That's correct. It is a contract, and the United States government, because they're the grantee, has to honor that, and they have to protect it. That's the purpose. If you go back to Summa Corporation, they address that issue. That is a contract. That's also in Fletcher versus Peck and many other court cases. But the very fact that that patent is forever. If it was not, then the Supreme Court in the Summa Corporation versus State of California 1984 case would just been thrown in the trash. They had to uphold it. The Supreme Court is the only Article III court in the United States other than the Federal Court of Trade. All of these other lower courts, if they're federal courts, are Article I or Article IV courts. They're not Article III. And the patent falls under Article III jurisdiction, which is constitutionally based, because the patent is issued out of a mandated authority and jurisdiction from the Constitution, Article 4, Section 3, Clause 2.
Well, this is just a side. It's a curiosity of mine. I've heard it said that because of the emergency war powers being granted to the executive branch, that there are Article II courts, like military courts, or under military.
That's true, but they deal with a whole different jurisdiction.
Got it. Okay, so the next question is, if the land patent has legal authority, can any lesser court rule on the force and effect of the land patent? I think you covered that.
No, they cannot. They have no authority to impede any kind of a ruling. They can affirm it. From that standpoint, they would have jurisdiction, but they cannot rule against it.
The next question is, does a color of title sheriff deed carry superiority to a land patent?
No, absolutely not.
Just the word color of title lets you know that it's a derivative of the land patent.
That is correct. There is no title other than the land patent title. And that title is an allodial title. It's not just a title, it's an allodial title.
Yeah, and these color of titles are just all administrative derivatives.
That's correct.
Yeah.
They're all administrative. that means that they're just puffs in the wind. They have no lawful standing.
Except in contract.
Yes.
Yep. Should the people, here's the next question. I think you'll like this one. Should the people of these United States of America be sanctioned, even criminally sanctioned, for updating, perfecting a land patent?
Well, absolutely no. Because the land patent is the lawful instrument of a God-given right. The right of land ownership is God-given. It's not government-given. The government only has to administer the administrative paperwork to convey that land to the private sector.
All right. So here's the next question. Is the following citation reliable? And I know you're familiar with this one. Weinman versus Gastrell. The court is bound by the supremacy clause of the Constitution to uphold the treaty, making your patent a statutory limitation throughout the land. And I think what that means is that there's statutes in every state that limit them from trespassing on that treaty and those patents.
That is correct. Here's what people do not understand. No court, even the United States Supreme Court, cannot rule against a treaty. The treaty is between nations.
Right.
The Supreme Court does not have that authority. That's the reason they have to uphold it. They have to defend that land patent because it's protected by treaty law.
Let's see. I think I have something here real quick, if I can get to it fast. So just real quick, maybe you could talk about why treaties between sovereign nations are different than what they call treaties between corporations.
That is correct. There are no assimilation at all.
Yeah.
Treaties have to be honored worldwide by all countries. One country can't go and defile another country's treaty. They are worldwide recognized and accepted as such.
Well, anyways, I can't find it fast enough, but I have the Michigan statutes here that talk about those statutory limits on the patents, that they have to honor them and record them. And but they're in every state. You just might not be able to find them online.
Yeah, that's correct. That's correct.
But they have to be there because treaties gave rise to the constitutions, and the constitutions gave rise to the federal statutes, which uphold the honor in those treaties and constitutions.
That is correct. That is absolutely correct.
And that's why the states have to have statutes so the administrative body can see their duties to honor these lawful instruments, these honorable instruments.
That is correct.
Because it's sacred honor that they're talking about.
That is correct.
Okay. Is this citation reliable? Cooper versus Aaron. No state legislator or executive or judicial officer can war against the Constitution without violating a solemn oath to support it.
That is correct.
But they do it every day. And why?
Because they're in dishonor. There's let me back up. Really important here. The Administrative Procedures Act was intended strictly for the purpose of controlling we, the people, in our land. That was the whole purpose of it, so that they could gain control, and then through that control, they could get money. They could extort money. It's called an unjust enrichment in law. But that's what they've done. It was totally for the purpose of divesting us from our God-given rights. All of the administrative process is primarily for that purpose.
And then this last question is, if a land patent maintains its lawful authority and people can be sanctioned for updating a patent or bringing it forward, ought not public servants and attorneys be sanctioned for attempting to eviscerate the patent and violating their oath?
Well, I've argued that very point for years. They take an oath. Judges, all public servants have to take an oath to support and defend the Constitution. A land patent is a constitutional document, and that document is sacred by virtue of its treaty, and it's a God-given right to own the land. And I want to see the authority that the state, or any state, federal, whatever, has the authority to circumvent our God-given rights. So the answer to that last question is absolutely. But now going back to the other question, there's no authority anywhere, and the authority for what I'm sharing with you is in Hooper versus Scheimer case. The Supreme Court states what is required to bring that, or the primary item is your chain of title. And if you have a chain of title that's tied from you back to the patent, then I'm telling you, you're home free. That's why that chain of title is so important and critical.
So just to help answer that question, then why are they doing it every day? Is because they see contracts that people have check boxes and have made applications and registrations and created all these contracts with the corporation. And under Article 1, Section 10 of the Constitution, it says no one can interfere with the obligation of contract. So I think there's a toxic controversy there between God-given rights and foreign Roman civil law, international commerce contracts, because I think under God's law, there's a variety of elements that have to be met to have a lawful contract, but in the Roman civil law legal system, there's just offer, acceptance, and consideration.
That is correct. You nailed it right there. Because you're really talking about two different types of contracts, and you just described that very well. The contract that we're talking about the patent, is a constitutional, guaranteed, and protected contract. And the authority behind that is our inalienable right, our God-given right to own land. No court has an authority to infringe upon that. And if you go to Corpus Juris Secundum 73B, it states very clearly that once the grantor grants a patent to the grantee, neither party can change anything in that land patent. In other words, it's in stone and it's forever.
Very nice. Okay, so if people would like to hear more or learn more about all of this, on January 22nd, Ron and I will be out in Wisconsin providing a presentation that goes into much more depth about this. I'm going to do a few hours on Friday night, and Ron is going to do all day on Saturday, January 22nd. So we would encourage you to come out to AmericanMeetingGroup.com and go to Ron's page, and you can get more information about that event and to register. So Ron, with that, I just want to thank you from the bottom of my heart for all you do and all you offer to the people. All those years, for the last few decades where you couldn't get anybody to listen, thank goodness at least they're starting to wake up now and doing everything they can to get to you.
Thank you very much, Robert. I appreciate that.
Can you see this document, Ron?
Yes, I can. Land Patents Act 21st, 1837. Okay?
Yes. So I found this document that I was trying to find earlier in the call. And so this is a Michigan statute, and this is the number of the statute, and it talks about land patents recording existing records, validation, and use as evidence. and the record of patent as evidence. I'm not going to read through the whole thing, but I just wanted to put it on the screen so people could pause it and read through it, and to help them find their own in their own state.
Exactly. Would you send that to me?
Yes.
Yeah. But what you're showing here is typical across the land. Every state has protective covenants of that land patent. I've got one here for Alabama. Boy, I mean, it's powerful. And you've heard me present that and read a portion of that during the patent seminars.
Yep.
Reason that I do, it shows that I'm just not speaking from an Oregon perspective or Oregon law or whatever. What you're seeing there is universal. The language may vary a little bit, the numbers will change, but the content of the document is the same. That patent has to be protected.
Yeah, they're all sacred principles. They come out of Scripture.
Because they're God-given rights.
Yeah.
To own that land is a God-given right, and people don't let that sink in.
Yeah, that's why the founders pledged their sacred honor.
That is correct. Exactly.
All right, my friend. Well, I think that's going to do it for today. Again, thank you so much for taking the time out and doing this. I think these are some things that people are going to come across more and more. These kind of techniques or strategies to cast doubt on your sacred rights and on these documents that were intended for your benefit. And there was a lot sacrificed to make sure that these remained available and created a foundation for this country. If you want protective covenants of the constitutions, which are the supreme law of the land, you should have land patents because they're the only true title to land.
That is correct.
It's not the supreme law of the real estate or the supreme law of the tenants, right?
Exactly. That's why it says land. You know, the other thing I might mention, and I need to run, Robert, and that is the fact that words have meaning. You know, and it's important that people start to understand land means land, not real estate.
To learn more about this information, contact us at glgse70n@gmail. Free yourself today.
We're excited to provide you with access to the most up-to-date technology and research that have successfully helped numerous individuals in the past. We're confident that they can do the same for you. Please don't hesitate to contact us if you have any questions or concerns. We highly recommend reviewing our information packet, which contains cutting-edge and proven knowledge. We believe that access to this information is important for everyone, and we encourage you to share it with your friends and family.